Sixth Amendment right to counsel. Once Sixth Amendment right to counsel attaches, police may not elicit incriminating statements outside the presence of defendant's counsel. Application. Rights attaches once charges have been filed, applies to all subsequent stages of judicial proceedings. The scope is is offense specific. Police can question defendant about any other crime without violating defendant's Sixth Amendment rights. Fifth versus Sixth Amendment right to counsel. Fifth Amendment right to counsel is not automatic. Accused must invoke the right by unambiguously requesting presence of counsel. Applies to any custodial interrogations, not offense specific. Once invoked, police must stop questioning on all subjects. Sixth Amendment right to counsel is automatic and it attaches once charges have been filed and at all subsequent stages. It's offense specific and police can question defendant about any other crimes. Right to effective counsel included in the Sixth Amendment right to counsel. To establish any effective assistance of counsel on appeal, defendant must show there's a reasonable probability that his trial's automatic outcome would have been different absent counsel's deficient performance. Pre-trial lineups and show-ups. Right to counsel. A suspect has a right to counsel at any post-charge in-person lineup or show-up. Does not apply to non-live identification procedures, such as photographic lineups or fingerprints. Lineups, witness is shown several possible suspects. In a show-up, witness is asked to identify a single suspect. Due process consideration. Defendant can attack pretrial identification processes or procedures as a denial of due process rights if 1. Identification is unnecessarily suggestive, and 2. There is a substantial likelihood of misidentification. Determined under the totality of the circumstances. Tough standard must be extremely suggestive. Perpetrator believed to be male and suspect is the only male in a lineup would likely violate the due process. Remedy for violation. Defendant may move to suppress any subsequent in-trial identifications made by the witness. Note, remedy for violation is rare because government can often prove the identifying witness has an independent source of identification to overcome the exculpatory rule or the exclusionary rule. Grand jury proceedings and indictments. Grand juries are required in federal court under the Fifth Amendment and are used to determine whether there is sufficient probable cause to bring charges against a suspect. Prosecutors present their cases to grand jury, which votes to issue an indictment if they find probable cause. Grand jury proceedings are secret. The suspect has no right to confront witnesses or attend proceedings. Witnesses are not entitled to Miranda warnings. Witnesses may not challenge a subpoena. Witnesses do not have the right to counsel inside a grand jury. Fifth Amendment privilege. Witness can refuse to testify for fear of self-incrimination. Immunity. Prosecutor can grant immunity in some form. Use or derive use immunity in exchange for potentially incriminating testimony. Exclusionary rule does not apply. An indictment can be based on evidence that would be inadmissible at trial. Pre-trial hearings, bail, right to speedy trial. Pre-trial preliminary hearings. may be required to determine if there is probable cause to detain a suspect. This is required if 1. Defendant is incarcerated or released on bail. Does not apply if defendant is released on sole condition that she appears for trial. 2. There has been no determination of probable cause. Not required if arrest was made with a warrant. Must occur within 48 hours of detention if required. Bail cannot be higher than necessary to ensure defendant will appear at trial. Detention without bail is constitutional, but a decision to refuse bail is immediately appealable. Arbitrary denial of bail violates the process. For denial of bail, government must show either A, defendant possess a right of flight risk, or B, defendant possess danger to the community. Right to a speedy trial. Sixth Amendment protects defendant from unreasonable delay between the time charges are filed and the beginning of the trial. Right attaches once defendant has been arrested or charged. Violations are determined by the totality of the circumstances. Factors include the length of delay, the reason for the delay, did defendant cause the delay, if delay has been prejudiced by defendant, where defendant asserted rights, remedy for violation, dismissal of case with prejudice. Plea bargains. A defendant may enter a plea bargain, but doing so waives his Sixth Amendment right to a jury trial. Requirements for a valid plea bargain. Judge must 1. Determine plea is voluntary and intelligently made, and 2. Ensure that defendant understands the nature of the charge and its critical elements, maximum authorized penalty, and any mandatory sentence, that defendant has a right to plead not guilty, and that defendant is waiving his right to a jury trial. Appellate courts will not disturb valid pleas unless A, plea was made involuntary due to a misunderstanding, B, the court took the plea that lacked jurisdiction, C, defendant had ineffective assistance of counsel, or D, the prosecutor failed to honor the plea. Contract theory of plea bargaining. Pleas will be enforced against both parties, but the judge is not required to accept or adhere to the agreement. The prosecutor can threaten defendant with more serious crime than he was initially charged with, and even follow through on such threats if defendant does not accept the plea.